All right, so we're beginning the policy meeting for June 4th, 2020. I think there's several issues that Executive Director Bergstrom is going to talk about. I think there's four pretty big issues. So I think I turn that over to you. And then if somebody wants to speak, I acknowledge them. I believe, just as a reminder to everybody, a lot of you may be in your office. I'm sitting in my kitchen counter. So I had my cell phone next to me and reminded myself to mute it. So if everybody can remember to do that as well. And then I will try to recognize people to speak. I'm not seeing anybody in the gallery. So I think if you unmute and state your name, and then I can just unmute to recognize you if that works. We'll go that route. So with that, I'll turn it over to the Executive Director to begin the policy discussion.
Thank you, Judge, and good morning to everyone. As the Judge indicated, if you have any questions or comments throughout, please direct those to the Judge, and she'll try to manage the discussion. First, I want to recognize staff and members for for putting up with this effort as we're trying to go remote. I hope this meeting is successful today. I do want to remind everyone that the meeting is being recorded and that we are also transcribing the meeting through the Zoom webinar feature. Because of that, it's really important that if you have a question or comment, that you state your name first and then provide the statement or comment. And that way in the transcription, we'll make sure we attribute it to the correct person. With that, you'll see that you should all see the PowerPoint slides that Ryan's posting. Today we're in the policy committee meeting, and what I'm showing you is just a list of the materials that are in the meeting materials for policy. And there's a couple of these things that we'll not discuss this morning, but we'll discuss during the formal meeting. But I do want to start with talking about sentencing guidelines generally, what the commission has been trying to do, and then we'll be moving into specific proposals and particularly Amendment 6. And at the end of the discussion of the various proposals before the commission, I want to talk a little bit about this mandate we have to do a certification of compliance linked to county intermediate punishment funds. So that's the substance of this morning's meeting, the discussion of four proposals, and we'll sort of bookend that with a quick discussion up front of the 8th edition guidelines and discussion of certification of compliance at the end. Next slide, Ryan. So just as a little background, and many commission members are certainly aware of this, but I think for the broader audience, it's important as context. The commission has been working for a number of years on a comprehensive rebuilding of the sentencing guidelines. And this is an effort that started back in 2014 with the establishment of a strategic planning work group that we had individuals from across the Commonwealth involved in a sort of a review of the sentencing guidelines. The mission was, if you're going to do it all over again, what would you do? And we got a lot of recommendations and suggestions out of that process. And then the commission took the report from that group and established subcommittees to review those, to vet those proposals or those recommendations and move them more towards something that the commission could consider for adoption. And so those subcommittees met between 2016 and 2019 to review those procedures. And then the other thing that was always in the background and then became a very focal point of some of these changes was the Justice Reinvestment Initiative, JRI-2. And with the conclusion of that in 2019, there were a number of recommendations specifically to the commission and really sort of hand in glove with the proposals that came out of the strategic planning work group. And so I mentioned all of that information because there's been an effort underway for many years to look at rebuilding the sentencing guidelines. And the rebuilding would focus really on three big factors, three fundamental factors. The first is offense gravity scores, how we assign or rank offenses for purposes of sentence recommendations. The prior record score, which some view as criminal history, and that's probably the area that has received the greatest attention, both in terms of rethinking prior record score and in terms of building in mechanisms to reduce the prior record score because of stale records and other things like that. And then the third are general sentence recommendations. And this is where the JRI 2 recommendations, I think, were most helpful in terms of recommending very focused sentence recommendations. Our guidelines are fairly broad and provide a lot of latitude to courts. And the recommendation out of JRI 2 was to try to narrow that and think more specifically about the various sentencing alternatives and the duration of sentences, and really try to be much more focused on those. These are advisory guidelines, so courts can always depart from the guidelines, move outside of the guidelines. But the idea of having more sort of narrow focused on the recommendations we start with, the starting point for sentencing, came out of JRI 2. So those are big issues that the Commission's been looking at, and those will really inform the 8th edition guidelines that we are working sort of on a parallel track with. Tied into the 8th edition guidelines is a rebuilding of our data information system. We developed an application in JNet called SGS Web many years ago, and it really is central to our data collection and central to the implementation of sentencing guidelines. And over the years, we've received a lot of additional mandates, parole guidelines, resentencing guidelines, recommitment ranges. And we really see, and we have seen, a need to rebuild SGS Web into a more modular function that's integrated to allow us to accommodate all of those things. And so sort of on a parallel track with the 8th edition guidelines is the rebuilding of SGS Web, because collecting sentencing data and then parole data and really having very detailed data that can be used throughout the system for research and analysis or for policy development is critically important. It's something the Commission does well and has done for a long time. And this is just sort of keeping us in the mix and improving methods. So I wanted to give you that as background about what the Commission is doing generally in terms of sentencing policy, because today we're going to be talking about just like a small wedge of that, and that is current amendments, Amendment 6 to the 7th edition guidelines, because this is really in response to JRI 2 and some very immediate needs to build into the guidelines. So next slide, please, Ryan. So as we start to discuss the Amendment 6, I've broken this into two categories. One is just some fundamentals of the guidelines that we used Amendment 6 as an opportunity to make some changes or clarifications. So you'll see, we'll have a discussion about our omnibus offense gravity score policy, about sentencing enhancements, both ones we have and ones that are proposed or have been discussed in the General Assembly. And then third, the assignment of offense gravity scores for any new offenses enacted since the 5th edition or the 5th Amendment to the guidelines. So those are sort of the basics that we'll cover as part of this Amendment 6. And then I guess the bulk of the changes to Amendment 6 are the JRI 2 recommendations or mandates. JRI 2 recommendations that came out of that working group were translated into two bills that were enacted by the General Assembly. Act 114 of 2019 really dealt with the idea of funding county probation and parole and other related things. So we'll talk about that separately a bit later. But Act 115 is really the act that mandated the Commission to make a lot of changes and incorporate a lot of changes into the sentencing guidelines. And that's really the substance of what you'll see today in Amendment 6. It includes things like the elimination of county and state IP as sentencing alternatives, the mandate to adopt guidelines for the use of restrictive conditions. These were the previous guidelines for county intermediate punishment. Adopting guidelines for probation that address intensity and duration. This is a new mandate and something that we've talked about as a Commission, but we have it built into Amendment 6 as a starting point. And then finally, recommendations for Department of Corrections programs. There's been a really a change in how people are admitted to various Department of Corrections programs. The former state intermediate punishment program, which was a person entered through a sentence by the court, is now the state drug treatment program, which is a program at DOC that the court designates eligibility at sentencing. So that and other programs are available at DOC. And the real change in the process is for the court to designate eligibility at the time of sentencing. And the default is if the person is otherwise eligible by statute and the court is silent, the person is eligible for those programs. So we'll be talking about how we try to build that into the sentencing guidelines. Ryan? Thank you. So the first issue we're going to talk about this morning, as far as the Amendment 6, is the omnibus policy. And let me just provide a little bit of background that you'll see on the slides here. And let's go back in time for a moment. Back, the first edition of the sentencing guidelines was implemented in 1982. And at that time, there were only a handful of offenses for which the commission actually went in and assigned a specific offense gravity score to the offense. Because the structure of the guidelines at that time was to just assume that for any offense, we look at the grade of the offense, and the assumption is the omnibus score, our default based on the grade of the offense, would apply. And only in those cases where the commission thought it was necessary to change that assignment, to increase it, or to what we call subcategorize, to split out some provisions, only in those cases did the commission actually do this separate offense gravity score assignment. Otherwise, the omnibus policy applied, and you look at the offense and you look at the grade, and the OGS was assigned based on the grade. So it was a very simple process, and as a result, the commission had a very small list of other offenses that the commission assigned offense gravity scores to. That really stayed in place for the most part through 2008. So the commission would maybe go in and get more detailed in terms of breaking out offenses and so forth, but for the most part, we used the omnibus offense gravity scores to link to the grade of the offense, to assign OGS values. Starting around 2008, and even before that, the commission had deployed SGS Web, the sentencing software, and in its research and in its policy development and a lot of other areas, we found that it would be much more helpful and we'd have much better information to help the General Assembly or to do impact analysis if we actually looked at the offense defined section of statute rather than just the grading of statute. So the guidelines were becoming much more granular. We could go into our data and look at a specific subsection of statute and be able to track those kind of offenses. And that gave the General Assembly a lot more information about impact or potential impact of legislation. And it helped us to study the impact of sentencing generally. We could do what we call attrition, where we could start with someone who was charged with a number of offenses and sort of watch the case move through the system because we're tracking it by what the person was charged with, the subsection of statute and so forth. And so it's been very helpful in a lot of ways to have this new process in place where we focus first on the offense defined section and then we look at the grade. And because of having everything automated, this has gotten to the point where we are that for every new offense and every new subsection of an offense, the commission assigns an offense gravity score. So we're very granular now. And the downside of this is this omnibus policy that we had that just said, look at the grade, let's go with that, has really not kept pace with how we do OGS assignments generally. So we've been trying as a commission over the years to sort of add to this policy, sort of move it along a bit and try to make sure that we identified exceptions where maybe what the commission had previously assigned continues to apply and other exceptions where the assumption is the omnibus score applies. And this is, I think, staff's effort to clarify all of that. And so, again, all of the stuff we're talking about this morning, all of these proposals, we are putting before the commission. We've talked about many of these before, but we're putting before the commission for approval to take to public hearings. So this is not an adoption meeting. This is just approval to take to public hearings. So there is more time to finesse things if necessary. But conceptually, we wanted to make sure we got this before the commission and provided any kind of any kind of changes necessary and try to get this out for public hearings. So here's the substance of the changes to the omnibus policy. What we're trying to do is, number one, separate out two categories of new offenses that we see. One is when the General Assembly creates an entirely new offense, a new section of statute. It's wholly new. There was nothing there before. And in that case, the omnibus policy works well. We just assign the offense gravity score based on the grade of the offense or the various grades that are there. That works pretty well. But the second category is where it gets complicated, and that is when the General Assembly takes an existing offense, an existing section of statute, and modifies it. And they modify it in two ways, three ways maybe. The first way is they just increase the grade assigned to that offense. The second way is to change the definition of the offense. And the third and most complicated is a combination of the two. And just this round of guidelines of review, there have been a number of cases where there was sort of a mixing and matching of things and a lot of changes internally to a statute through an amendment. And there's no clear rules that we have in place for that. So we're trying to come up with cleaner rules for the application of the omnibus score. If it's a new offense, we just assign the offense gravity score. And if it's the omnibus offense gravity score. And if it's an existing offense, we give deference to what the commission has assigned to that offense. And the deference is that we basically look at the offense and we say, if it has in effect the same grade as the commission already had in place, we're going to use that OGS assignment and just keep that in place. And the commission can always review this later and modify it. So Ryan, if you could move to the next slide. So the proposal, as I said, is number one, to split out in the definition of the omnibus policy, whether it's a new offense or a modified offense, an amended statute or an entirely new statute. And then to use the defaults we already have in place to create exceptions. So for instance, if you look at 2I, it says when the grade or statutory maximum of a sentence has increased, the omnibus score shall apply unless application of the section would result in a lower offense gravity score. And then we have the opposite if the new grade of the offense decreases. So we would retain that as our general policy. We clean up the language a little bit, but we retain that as a general policy. Next slide, Ryan. And one more slide, please. But we're adding a second provision to try to get to that situation where the General Assembly amends a statute and it changes both the definition and the grade of the offenses. It looks almost entirely new, but there's substance there before. And think about a case where the commission spent time reviewing an offense in a statute, assigning, let's say, a higher offense gravity score to it. And then because of the changes, the amendments in the General Assembly, we may have a situation where the definition changed and the grade changed. And the idea of just defaulting to the omnibus score or defaulting to the previous assignment, neither of those is a great fit. So we've come up with this sort of combination area where we have some rules in place that would apply in those kind of situations. And again, the deference would be to what the commission has assigned to that offense or that subsection of statute. But there are going to be times when we have an offense that for, let's say for a felony 2, has multiple offense gravity score assignments. And so in those situations, our assumption would be that the lowest offense gravity score would apply as the omnibus policy. And if and then we have, built into that exceptions in terms of the use of the omnibus OGS score. So it's a little bit complicated. We had provided this material to you in advance. And again, this is just for purposes of approving to go to public hearings. But I think staff would encourage you to approve as part of this amendment, this change to the omnibus policy in order to get something on the table, see if it has to be refined further, but at least give us clear rules about how to apply the omnibus score or the policy when there's a change in legislation. I know that was a long ramble, and I apologize. It's a pretty complicated thing to unpack, but let me just stop for a moment, see if there are any questions through Judge Bernstein, and then I'll move forward.
I'm not seeing any alerts on the screen that are indicating that there are any questions. If somebody, I know on my screen, there's a place where it says raise hand, but if anybody wants to unmute and state their name, if they have a question, you can do so at this time. Assuming that we're not hearing from anybody, I would assume there's no questions. Thank you.
Great, thank you. One final tag onto this policy. If you look at our existing policy, and we've had it in place for a long time, we have a number of offense gravity score assignments, these omnibus OGS assignments, these defaults that we have in place. And just to go through the list, if a new offense is created and it's an M3, it automatically is assigned an OGS of 1, an M2 an OGS of 2, and an M1 an OGS of 3. If a new offense is created and the grade assigned to it is an F3, it has an omnibus score, an automatic assignment of 5. For an F2, it's a 7. And for an F1, it's an 8. But what we've been finding is there are increasingly a number of statutes enacted by the General Assembly where the classification is a felony 1, but the statutory max is greater than 20 years, sort of a super felony. And applying the OGS 8 as the default for a super felony just doesn't seem quite in line with the other defaults we have in place. So staff, as part of this policy, is recommending that we create a new omnibus offense gravity score for felony 1s with a statutory max of greater than 20 years and assign that an offense gravity score of 10. Now, the commission at some later time could increase the sentence recommendation, the OGS assignment for that offense. But as a default, you know, the value that would click in immediately upon adoption would be the omnibus score, and that would be for a felony 1 with a statutory max greater than 20 years would be an OGS 10. If there's no comments or questions about that, then I'll move on to the next policy. Looks good. Okay, thank you. So the next category that we're going to are enhancements. And we dealt with a number of these previously, so this should not be new, but we'll do a quick recap just in case there's any questions or comments. And then we've identified 3 additional ones which are embedded in bills moving through the General Assembly, but have not been enacted yet. So the commission does not have to take any action on them. But the thing is, if you know, because of the time cycle that we need to go through to adopt guidelines, if any of these warrant some action now by the General Assembly, by the commission, even if the General Assembly has not enacted them, the commission has the authority to enact or to consider enhancements even without a legislative mandate. So the 2 that are listed that we've talked about before and that are built into the proposal. Number 1 is the domestic violence enhancement. For the domestic violence enhancements, the commission adopted this during the last amendment to the guidelines. This was a statutory mandate. And one of the things that we've heard from practitioners since adopting this was, and let me back up, you'll recall that the mandate was to require, to address some type of enhancement when a minor is within sight or sound of a domestic violence incident. And what the commission decided to do was create a 2-step enhancement. The first step was to increase the offense gravity score for the object offense if that circumstance, if there was domestic violence. And then the second step was if a minor was within sight or sound, to recommend the court order the cost of treatment against the defendant. And when we've talked to practitioners about this enhancement, which is now in place, we heard a number of comments. One was a concern about limiting to treatment costs when there were also costs associated with the assessment of the minor. A second and third issue that was raised, both related to sort of caps. One of the questions was, should there be some type of limitation on the ordering of these costs related to evaluations or treatment, either in terms of timeline or in terms of dollar amount. That was brought to the commission. The commission did not have, I don't think, supported any kind of change to the policy at that time. A third thing that was raised was whether there should be any nexus requirement, whether there should be proof requirement, at sentencing regarding the relationship between the minor's need for treatment and the specific offense that was before the court. And I think we raised that before, and I don't think the commission thought there was a practical way of getting at that. So at this point, at least for purpose of this enhancement or this modification of the enhancement, staff has recommended that we just insert the addition of assessment costs as something that would be recommended to the court when this enhancement applies. So I'll pause for any kind of comments or questions.
This is Judge Bernstein. I just thought maybe we should make a record since we have a transcript. This is an opportunity for anybody to speak. So you can either push the selection for raise hand or unmute and identify yourself if you have any questions. None being noted.
Thank you, Judge. Moving to the next enhancement, and we discussed this in some detail at the last meeting, I believe, but this is an enhancement related to sexual extortion. So it deals with section 3133 of Title 18. The current offense gravity score for the F3 provisions that this would apply to is an OGS 5, and what the enhancement would do would increase that offense gravity score to a 6, so a one-step increase, which is a common practice that the commission has for enhancements. The enhancement applies in 3 circumstances. Number 1, when the complainant is under 18 years of age. Number 2, when the complainant has an intellectual disability. And number 3, when the actor holds a position of trust or supervisory or disciplinary power over the complainant. So again, the commission discussed this before. I think there was support for a 1 OGS increase when those factors are determined by the court to be present. And again, unless there's any comments or questions, we'll assume that's in there and we'll move forward. All right. So now the remaining 3 are matters that are before the General Assembly but have not been enacted. But the commission has the authority to at least include these for public comment, if nothing else, or to build them into the guidelines, even if the legislation isn't enacted. The first one is House Bill 1827. This bill has passed the House and it's in the Senate. It deals with causing or aiding suicide, which is section 2505 of Title 18. Similar to the sexual extortion enhancement, it identifies 2 factors that would be the source of the enhancement. If a victim was under 18 years of age, and if the victim had intellectual disabilities. So the same process we have in place for other enhancements, the 1-point increase in the offense gravity score could be built into the guidelines as an enhancement for this offense, for sexual extortion. I'm sorry, for causing or aiding suicide. The one thing that is I guess a cap on some of this is there are a number of provisions of section 2505. There are provisions of 2505 that are assigned murder 1, murder 2, or murder 3 penalties. And so for those three offenses, an offense gravity score enhancement would not work because they're already capped out. We've dealt with this before, and we just recognize it's at the upper limit, and enhancement really can't apply if we're looking at duration. So those are sort of off the table. But for all of the other offenses, there are felony 1, felony 2, misdemeanor 1, and misdemeanor 2 provisions that have offense gravity score assignments that would allow for a 1-point increase. And so that is the recommendation that's been built into the enhancement. If the commission would want to add this as an enhancement to this round, this amendment, if for no other reason for public comment, this would be a mechanism to do that. But again, the commission we do not have a mandate to do this. But if it would pass the General Assembly, it would have to wait for another cycle of changes to the commission's guidelines before being implemented. So this is sort of an opportunity to plug it in if you're interested. So again, with that, let me pause, see if there's any comments or questions.
Judge Bernstein, no questions are noted.
Thank you, Judge. So staff will go ahead and include that with the 1-point increase. And then the commission will have a chance to receive comments and make a decision in September whether to continue to include it. The next matter before the General Assembly is interactive wireless communication device, House Bill 37. Again, this has been passed by the House. It is now in the Senate. It appears fairly technical, and you know it's important to do a deeper dive, I think. But keep in mind that we have an enhancement in place right now for texting, or for, I think the term that's used is prohibited text-based communication. And I think the substance of this bill is to replace prohibited text-based communication with the term and the definition for interactive wireless communication device. So this is really more a modification of an existing enhancement than the creation of something entirely new, although there's a difference in the definition. But this applies to a number of offenses, I think ag assault by vehicle and homicide by vehicle. So again, in this case, we may have to wait to see if the General Assembly enacts this, because it is a change in statute. But the enhancement would be, I think, pretty straightforward, because it's sort of the swapping out of one category related to text-based communication with another, now called interactive wireless communication device. So we could make a note of this in the comment regarding the guidelines, that there is this proposal and it could be a swapping, and that I can talk to counsel about whether that would be adequate to give public notice and receive public comment, so that at the September meeting, if we saw that there was progress on the legislation, we could swap the one with the other. Professor Mistick, I'm not sure if you'd like to opine on that at all, or if...
I would have no objection to proceeding in the manner you described. I think we would meet our notice requirements.
Thank you. Judge, any other comments or questions?
I'm not noting any on my screen.
Thank you.
We're good.
So the final enhancement deals with sexual abuse of children. This is child pornography. As you know, there is the commission has an enhancement for this. It's a very detailed and complicated enhancement because the statute itself has a lot of provisions related to the enhancement. So that is in place under the current guidelines. The bill introduced, Senate Bill 1075, has only been introduced in the General Assembly. And it does not change anything that we're doing, it just adds to it. And it adds a couple of provisions to the existing enhancement requirement. And one is that the commission would add to the enhancement provisions if the child was known to the defendant. So keep in mind, this is about child pornography, and the enhancement is built around the images that you're looking at, number of images, the nature of the images. And what this says is, if in those images there is a child that is known to the defendant, then there's an increase or is an enhancement that would be added by the commission. And then there's a second enhancement, and this applies as much to the grading of the offense. So it would increase the grade of the offense if, and let me see if I can have this language right, if the depiction of indecent contact with the child was of a child less than 6 years of age or a prepubescent child. So again, it's a new provision that would increase the grading of the offense, and then the commission would align that with the enhancement. So again, this has not been enacted, and this was only introduced in the Senate, and so it hasn't had final action even in the Senate. But because we have an existing enhancement, I wanted to bring it to your attention. Not sure if we can do anything at this time unless the commission wanted to actively include these provisions in our enhancement if there was support for it, absent a legislative mandate, whether anticipating action by the General Assembly or because the commission feels it's an appropriate thing to add to the enhancement. The only thing that would be missing is the change in the grade, because that would have to be enacted by statute. That can't be handled by an enhancement. So Judge Bernstein.
I'm unmuting. I don't know any questions, so look good to go.
Okay, thank you. I think what we'll do on that provision for the sexual abuse of children is see if staff can provide some type of information provided to members before we publish any kind of proposal and determine what to do. We could, again, as we said with the previous one, we could put it in the commentary to the guideline proposal to try to solicit comments from the public so that at the June meeting, at the September meeting, the commission would have any kind of public comment on whether to include that. So maybe that would be the safe approach. And I see a recognition from Professor Mystic, so I'm going to assume that's the path we'll take. Thank you all. Okay, sorry for this is very tedious, I know, but nature of the business, I guess. We're going to move to new offenses. I'm going to ask Diane to help walk us through this. We've covered most of these during previous commission meetings. There are, I think, a couple of new statutes that maybe we didn't discuss. And for Ryan's purposes, I think we have a separate document that we had in the materials that provides sort of more detailed on these listing of offenses and the offense gravity score recommendations that the commission that were made to the commission. The commission, I think, accepted. So Ryan, if you have that other document available, if you could swap this, and then I'm going to ask Diane to just briefly review any of the issues related to it.
Sure. We'll start with trafficking in individuals. This is 183011. We have a
Hey, Diane, I'm having a tough time hearing you, so maybe you could get closer to your microphone.
Okay. We're starting with 3011. Trafficking in the individuals. We have a grade increase from an F2 to F1. We're recommending a base of OGS 10. And if a minor is involved, we increase that to an OGS of 12. And then we move on to A3 and 4, which are new. These are F2s, and we're recommending an OGS of 9. Patronizing a victim of sexual servitude, we have a grade increase from an F2 to F1. For the F1, we're suggesting an OGS of 10 and then increasing that to an 11 if there's a minor victim. We have some new subsections for that if there's reckless disregard. The base is an F3, and we're recommending an OGS of 6 and increasing that to a 7 if there's a minor victim. For the A2, which is a second or subsequent offense, we're recommending a base OGS of 9 and increasing that to a 10 if there's a minor victim. Then we move on to 183132, female mutilation. We're recommending a base of OGS 12 for the F1, and then an OGS of 11 if the parent consents or the parent permits removal of the child from the state. And then we move on to the enhancement, which is the sexual extortion. And that Mark already covered this, I'll just be brief, but there's really four offenses with that. Engage in sexual conduct, produce or disseminate an image, solicit or demand payment, or threaten to disseminate an image or demand payment for removal of an image. The M3 is a base, that's the first offense. We're recommending an OGS of 3. If it's a second or subsequent offense, it's an OGS 5 for an F3. And again, those circumstances, which are the enhancement, we're recommending an OGS of 6 if the individual is under 18, intellectual disability, or the offender's position. Then we move on. That was quite a long list. We have an increase in 236311, failure to report or refer child sexual abuse. It increases to an F2. We're recommending an OGS of 7. The continuing course of conduct also increases. This is to an F3, and we're recommending an OGS of 5. There's several new, more obscure offenses. On trespass on private property while hunting, no authorization. A second or subsequent offense is an M. We're recommending the omnibus, which is a 1 OGS. And then no authorization defines order. Again, that's an M OGS 1. But we're recommending an increase to an OGS 2 if it's a second or subsequent offense. And then we have 626163, which is the parolee homicide review team. That's a breach in confidentiality of information. It's an M3. And we're recommending the omnibus OGS, which is a 1. And I think that's it, Mark.
Thank you, Diane. I'll turn it back to Judge Bernstein and also ask Ryan to be prepared to switch over to the other slides. Thanks, Judge.
All right, any questions? All right, and I think we lost one of our participants to another meeting, but there's no questions, so we can go forward.
Okay, great. Thank you, Judge. So those will be incorporated, or those are incorporated into the offense listing at 303.15. Now we're going to turn to, so next slide, please. Now we're going to turn to the JRI 2 issues and the incorporation of these into Amendment 6. During the last meeting, we spent some time talking about sort of the policy dimensions of this, and then talking about some specific recommendations, particularly around probation guidelines. And the staff went back and worked on it, and then this proposal was provided to members last week. And so I know you've had this before you. So let me give you a high-level thing, and then we'll go into some of the details. So at a high level, JRI 2 repealed county and state intermediate punishment as sentencing alternatives. So at the time of sentencing, we no longer have those two tools, and there have been mechanisms to sort of address both of those programs, which still exist. So county intermediate punishment was eliminated, but in effect at sentencing, it has now become probation with restrictive conditions. And state intermediate punishment was eliminated as a sentencing option, but it now is a program at the Department of Corrections called the State Drug Treatment Program. And the way the person gets into that program now differs than the sentence to SIP. So if you recall in the past, if someone was eligible and appropriate and recommended for state IP, the court would refer the person to the Department of Corrections before sentencing. If the DOC found the person to be appropriate and eligible, they would communicate back to the court and to the parties, and then the court remotely could sentence the person to the 2-year SIP program. Under the new provisions for the state drug treatment program, the court imposes a state prison sentence, but identifies the person as eligible or as not ineligible. And then when the Department of Corrections is reviewing the case during classification, they will be able to identify whether it's appropriate to place the person in this program. And then everything about the program continues to operate as it did. Generally a 2-year program. If you successfully complete the program, you successfully complete that sentence of confinement. So that's sort of the new wrinkle. There's other details, but what we tried to do was embed all those details into the text of the guidelines so that courts are aware of all that. So those are the two structural changes that we had to accommodate, built into the guidelines, change, and so forth. Then the specific duties get to the next two bullets. First was we're required to create probation guidelines and guidelines for restrictive conditions. And you'll see this takes a lot of ink, but it's been incorporated into the text of the guidelines in a number of different areas, and we'll highlight those changes. And then the final bullet is that provision about changing the mechanism for placing people into programs at the Department of Corrections, where the assumption is the court is imposing a state prison sentence, designating eligibility or appropriateness, and then the Department of Corrections has the latitude to assign people in any of the eligible programs. And they have a system in place to consider that, to try to figure out what the best fit is. And so it's not just, I talked about state IP switching over to the state drug treatment program, but there's actually 4 programs that are in play. There's the previously existing state motivational boot camp that continues to exist, and it's one of the programs. There's the drug treatment program. There is the triple RI program that we've had in place, the recidivism risk reduction incentive program. And there's a new program called short sentence parole. And so all of those are sort of in the mix. When a person comes in the door at DOC, goes through classification, the DOC is going to try to figure out if any of those or which one of those would apply in this case, or if the person is going to be handled regularly as a regular person at the Department of Corrections and subject to parole review at the minimum. So that structurally is the change in this that we had to build into the guidelines. Next slide. So let's take one of these at a time. We'll start with the guidelines for restrictive conditions. So keep in mind that guidelines for restrictive conditions succeeds or follows the previous guidelines for county intermediate punishment. And for those guidelines for county intermediate punishment, the commission over a number of years had come up with a number of ways in which county IP restrictive programs, things like inpatient treatment or house arrest and electronic monitoring, other types of restrictive programs, could be a one-to-one trade-off with our recommendations for confinement. So we kept to that structure. And I think we can think about like a 3-tier approach to the use of restrictive conditions. So the first is, this is a case where the court is looking to trade off confinement in a facility to restrictive programs in the community. And so it's built around retribution and it's built around our guidelines. So if our guidelines are recommending, a 6 to 12 month period of confinement in a county jail, that would relate to someone getting a term of probation, and within that 6 to 12 months of a restrictive program like house arrest or electronic monitoring. So that's something we've had in place for a long time. It's sort of a one-to-one trade-off, and that's embedded in this new text in the guidelines. The second approach that has been in the guidelines has been almost like a paradigm shift. It's much more of a medical model, and we've had this in place since the 90s. And the idea was, if someone is drug dependent, the idea of some kind of retributive value, X number of months of confinement or punishment, automatically translates to the amount of time in treatment, didn't make much sense. But what the commission did build into our policies was, if someone is level 3 or 4 in the guidelines and is drug dependent, then a clinically prescribed treatment program could be used in lieu of the recommendation that the commission otherwise has. So that was a pretty big change in how the commission was viewing these kind of things. And so that continues to be in place. We continue to have the provision in place that if someone's level 3 and 4, and if they're determined to be drug dependent, the court can use a probation with restrictive conditions, drug treatment, et cetera, in lieu of the recommended confinement sentence. So that's the restrictive conditions. The third type of restrictive condition is when it takes into account to some degree the work the commission has done on risk and needs assessment. And one of the issues is, if someone is low risk and low needs, the research says less is more. So let's say we have someone who is recommended for some type of restrictive programming or confinement of 3 to 6 months. But what if they're low risk and low needs? Well, there should be a mechanism to recognize that maybe that intensity of supervision is not necessary. And so when we're talking about community corrections, community sanctions, one of the considerations that is built into this is that a mitigating factor could be that the person is low risk and low needs and does not require what we're recommending in terms of confinement. And if in the community, the duration or the intensity of supervision may be lower because it's just not necessary. So that would be a very individualized consideration, looking at individualized information and using that to inform community supervision, which is sort of the basis around the risk model. And at the upper end, if someone is high risk and high needs, and we're talking about community supervision, that person might be a great candidate for something like a problem-solving court. So thinking about not using risk and needs to increase a punishment or decrease a punishment necessarily, but particularly to think about what's the best approach in the community. And tied into our guidelines is the proposal, the recommendation, the effort to just make sure courts have more information at sentencing to make better decisions. So back up 1 minute, Ryan. Thank you. So the restrictive conditions, again, look very much like the county intermediate punishment recommendations we had. The one thing that we've added to this that is new relates to probation guidelines generally, because the commission is required not only to consider the intensity of supervision, and that's what these restrictive conditions are, but also to consider the duration of supervision. And so if you look at this provision, it says the duration of an aggregate term of probation imposed during a judicial proceeding, so during a sentencing hearing, shall not exceed 10 years, and the duration of the restrictive conditions shall not exceed the suggested months of the minimum confinement. So the new addition here is that we're saying for a sentence being imposed to probation with restrictive conditions, the sort of the cap that we'd recommend in terms of an aggregate sentence for an offender is a maximum of 10 years of probation supervision, of which the restrictive period would be in line with our recommendations. So, Judge, let me turn it back to you. That was a whole lot on guidelines for restrictive conditions, but take it away.
Okay, so this is Judge Tamara Bernstein, and I have a question before anybody else might. My understanding is you're saying that the recommendations are the restrictive component of that probation is recommended to not exceed the minimum of the standard range of recommendation for incarceration.
That's correct, Judge.
Okay, so if a judge varies from that, they would need to put reasons on the record.
That's correct, except the one exception we already have built in is that clinical treatment. If someone's drug dependent and you have a clinical recommendation, that in effect supersedes the guideline recommendation because you're sort of taking a different approach. You're doing a treatment approach. But otherwise, the other thing I didn't mention before, and of course is built into this, is for DUI sentences. You know, there's provisions that allow certain programs to be used in lieu of the DUI mandatories. And so that's pretty much statutory, but that's also built in as an exception.
Okay, so just one more follow-up question. Clinical treatment exception, is that, I'm assuming it is because everything is defined, is because we have like a day reporting center, we have inpatient, we have intensive outpatient. Do those all fall under the definition?
Yeah, I think under the guidelines, and again, these were established back in the 90s, and we've had them. I think we've continued to hold to those. The Department of Drug and Alcohol Programs has standards in place for assessments of individuals. It used to be the PCPC. It might still be, but a clinical evaluation or assessment of the offender for dependency, and then a treatment plan based on level of care and intensity of care, duration of care, those kind of things. That sort of package, that clinical recommendation is the trade-off. So whether that's delivered through a day reporting center or an inpatient treatment, outpatient treatment, whatever the clinical recommendation is, that would serve as an alternative or an equivalent to the guideline recommendation.
Okay, since there's no more questions from me, I'm wondering, is there anybody else who has a question at this point? You can either push the raise hand function or unmute and identify yourself. There being no questions, we can go ahead and move on. Thank you.
Thank you. And I should just point out, I guess, one other thing as we transition to the next slide, and that is this duration of probation. You know, we talked about this last meeting, and clearly there's been a lot of activity in the General Assembly around maximum periods of probation supervision, and some of the legislation would recommend caps of 3 years for misdemeanors and 5 years for felonies, and clearly you'll see some of that showing up in subsequent recommendations, and the JRI working group and the JRI recommendations really focused on that 3 and 5 year sort of zone. And I think that's really, there's a lot of evidence behind that. And if you just think about all the work we've done on studying recidivism, we usually think about a 3 or 5 year sort of street time as the period that we're looking at for recidivism. And we say if someone hits, 5 years, you're sort of plateauing on additional recidivism. It's not total, but it levels off quite a bit. In fact, it starts leveling off after 3 years. And so that certainly is one of the factors and something that we've discussed as a commission. But a second factor that we've discussed, especially when we've been looking at 8th edition issues and at the prior record score, is some of the research by Professor Al Bloomstein at Carnegie Mellon and his colleagues around what's called redemption, and sort of the idea of when does someone who has had prior criminal activity start looking like everyone else in terms of risk of reoffending. And Professor Bloomstein and others have done really sophisticated research on this, and it depends on the type of offense and things like that. But I think when you look at that research, they talk more in terms of like 10 years or 12 years or 8 years or something like that. And so I think one of the things staff was thinking about when, building some of these proposals is Maybe the misdemeanor felony thing is a great breakout, but we have high misdemeanors in Pennsylvania, and there may be other measures. And as a starting point, we thought for this higher category of restrictive conditions, allowing for up to a 10-year maximum period of supervision of probation was warranted based on some of that research. And then as we go to the next slide, Ryan, when we get down to probation recommendations where we're not having restrictive conditions, this is just straight probation, non-restrictive conditions, we think the timeline should be shorter. And so you'll see here that what we try to do is build into the guidelines a recognition that probation alone, without restrictive conditions, is one of a number of restorative sanctions that we have in the guidelines. And in the guidelines since the 90s, we've had this label, RS, restorative sanctions, where we talk about non-confinement options. And although probation sort of gets the focus, there are other non-confinement options, things like guilt without further penalty, or economic sanctions, or community service. So we wanted to make sure we thought sort of holistically about not only that they're available, but promoting the use of those. Sometimes just promoting community service or some non-confinement option in lieu of even probation supervision. But for those cases where probation is being used as a restorative sanction, as a non-restrictive sanction, we wanted to build in some of the recommendations linked to what we've heard from JRI 2. So there's two approaches to this. One is that we wanted to look within the matrix itself, and for each cell of the matrix where restorative sanctions is an option, to make a recommendation. If probation is being used, what's the duration of that? And then we also wanted to think about aggregate sentences. What should the probation period be for an entire sentencing hearing when you can run things consecutively or concurrently? And so at the individual level, on an individual sentence, we came up with just two categories: P1, so probation for 1 year, and P2, probation for 2 years. And then we had a broader policy that says the recommended cap on probation for when used without restrictive conditions would be 5 years. And so, Ryan, if you could go to the next slide, we'll show you how this builds into the guidelines. And so this is a reformatted set of a copy of the matrix. And really all the attention is sort of down on the lower left-hand corner. So if we start at RS at what we call level 1, so offense gravity score 1 and 2 and prior record score 0, you'll see that RS is listed there. And we don't list any probation values. And that is because, the commission, aside from all of these other guideline recommendations, was required and did enact guidelines for fines and community service years ago. And we've had them in the text of the guidelines for a long time, but they're really a secondary consideration. And so we thought this might be an opportunity to actually put those forward, put them into the matrix, especially in those cells where restorative sanctions is part of the standard range option. And for level 1, where these are, first-time offenders with relatively minor offenses, we thought, courts have discretion. These are advisory guidelines. Courts can do other things, but as a recommendation, as a starting point for sentencing, in those cells, maybe we put forward that would be an area where consideration of just fines or community service might make sense as a sole sanction. And what we highlight there, and it's a little hard to see on this view, but you can see it in the materials you have or what we've posted, is we just put in the hour ranges that we have in the text of the guidelines, the hours of community service. And if some of you may recall, when we were developing these guidelines for hours of community service, the idea was we wanted to make sure there was an alternative to the use of monetary sanctions, that, almost like a day fine system, we would identify the number of hours that we were recommending of community service. And to the degree that a fine was being imposed, it could take into account those number of hours and the person's, either the minimum wage or what the person's hourly rate is, hourly wage is, as sort of a trade-off, a mechanism for relating community service hours to a fine, which is more proportional. Again, sort of a day fines model. But the focus here is really on just recommending or reminding courts that community service is one of those options, and it might be a sole sanction option. And if that was in the mix, the place where it would be most prominent is level 1, where we're just recommending restorative sanctions. So if you move to level 2, that's the white zone there, the next one up. You'll see that, for level 2, the definition of level 2 is that these are cells in which restorative sanction is always part of the standard range. But the standard range also includes some period of county confinement. That's the definition of level 2. And so this is really a zone of the guidelines where if probation is going to be used without restrictive conditions, this would be the place. And so when probation is being used without restrictive conditions, that's where we've plugged in those durations of probation recommendations. And that's where you'll see the P1s and P2s. So the court could say, yeah, this is a non-confinement sentence. This is, in this cell, the recommendation is P2 if I'm going to use probation. For this, the recommendation for this case would be 2 years of probation. But there's the other option there of community service, and the court always has other restorative sanction options. And at level 2, if the court decides this is a confinement sentence, look at a cell that has RS to 4, and the court says, yeah, 3 months of confinement is part of this, well, then there's the opportunity to use probation with restrictive conditions in lieu of confinement. So trying to use those other kind of programs. And again, at the point of sentencing, when you're looking at the sentencing hearing, the judicial proceeding, that's where we'd say, yeah, you might have a bunch of counts and deciding whether to run concurrent, consecutive. If this is non-confinement, we'd suggest that the cap on probation supervision be 5 years. And if this is probation with restrictive conditions, that cap could go up to 10 years. And that latter part, probation with restrictive conditions, really comes into play when you move up to the next 2 levels. The blue level is level 3, the yellow level is level 4. These have been traditionally the targets for the use of county intermediate punishment in lieu of county confinement. And so the probation with restrictive conditions applies in this area. So what we talked about just on the previous slide about this one-to-one trade-off or the treatment trade-off for drug-dependent offenders, that applies at levels 3 and 4. So that's the trade-off provision where probation with restrictive conditions could apply and where we'd recommend a capping at 10 years of probation. So that was a lot of information, but let me pause and turn it to Judge Bernstein.
Okay, Judge Bernstein, any questions? I guess I have one question again. On the slides that were previous, where I was reading, for example, shall not exceed the probation, is that a mandate? Is it a requirement that the courts cannot go beyond that?
Yeah, thank you. That's a really good question. Ryan, if you could turn to that previous slide. Thank you. When you look at the sentencing guidelines, I guess, contextually, keep in mind, these are advisory guidelines. So on the one hand, courts have all the discretion they want, subject to appellate review, of going outside the guidelines, either aggravated or mitigated or departures completely, and providing reasons for the record. But the commission has an obligation to create guidelines where we're saying to the court, well, here are the rules of the road under the guidelines, and here's our recommendation. So guidelines are usually use the word shall, because we're saying, yeah, these are the rules. But once you establish what the sentence recommendation is, then it's up to the court to decide whether to go with that or to depart. So, so that's why saying shall in terms of 5-year max or shall in terms of 10-year max is guideline language, but that doesn't bar the court from doing more, whatever's legally possible.
All right. Thank you. That explanation makes great sense. I think it's my law school when I see the word shall.
Yeah.
But I understand it's a shall, but within the context of a guideline.
Right.
If you can hear my dog, I apologize, everybody. Any other questions before I mute? All right. Go ahead.
Great, thank you. So Ryan, if you could advance. And now we're going to move to, that completes the Amendment 6 of the guidelines, the proposal. So during our formal business, yes.
I'm sorry, it's Todd.
Yes.
I was sitting here thinking, as Judge Bernstein, because I asked the exact same question that Judge Bernstein just asked.
You did.
And I was just curious if any other members of the commission were concerned that that would not be read as discretionary for some reason, or that it would not be read sort of in the larger context that the guidelines are advisory. Does anyone else have any thoughts on that? Because it's just interesting to me that both Judge Bernstein and I picked up on the exact same, that word shall jumped off the page at me too. And so.
Yeah, if I could place in a comment, and then I'm really happy to hear, because, you know, you guys decide what you want as the text. But one of the things we did in the text of the guidelines, and we just didn't put it in the slides, but if you look at the text of the guidelines, we have this section in the guidelines that addresses sentencing levels and sentencing purposes. It's sort of it's almost like a policy statement of the commission, where we talk about purposes of sentencing, recommendations the commission's making, and so forth. And we have really expanded that section. And what we did was we plugged into that just a whole paragraph about the commission's guidelines being advisory. And in fact, we quoted liberally from Chief Justice Cappy in a case that dealt with the guidelines being advisory, to capture the language that makes very clear to everyone, and certainly judges, that these are advisory guidelines. So the guidelines speak, you know, we have to be clear about what the guidelines intend, but then we have to be clear that the guidelines are advisory. And we plug that in exactly to try to address this issue of separating the two. And then we also, in the guidelines, then went into a lot more detail about the correctional programs, things like that. So I'm sorry we didn't go into any detail on that, but I just wanted everyone to know that that's part of what we've put out there in the guidelines.
Okay, this is Judge Bernstein back on. Can you go forward one more slide back to the matrix? So I was just going to say something, and Representative Stevens, I was thinking about this. For judges to really be understanding what this even represents, there's going to have to be some trainings. I mean, I'm not saying that a lot of judges aren't rereading the entire sentencing code, but for those who aren't, most of us are going to the trainings. And now that I'm thinking of it, I guess in a sense, if you went up to the, OGS 6 prior record score 0 of a 3 to 12, so the bottom of the standard guideline range shall be 3 months, technically speaking. So although it's a guideline, it's advisory, it is permanent in what its number is fixed to. Is that perhaps maybe, I know that, but I do know that if somebody were just like me, flipping through to say, gosh, what were those things in probation? The word shall does, we are heavily trained in that word. So I would say maybe the first thing, and Representative Stevens, maybe you can weigh in on this as well, perhaps see if with the language as it is, and then the trainings that would follow up, I'm assuming as a result of this, maybe would remedy that along with the language. Because otherwise we're going to have to put little asterisks or something every time the word shall is in there to say, remember, this is a shall within a guideline range. But I don't know, I'm interested in your thoughts if you have any extra, Representative Stevens.
I mean, I guess you're right. I mean, it's all about training, because you're right. It's a shall within a recommendation. So we're, yeah, I mean, probably training is the only way we can solve that problem. But I just thought it was interesting that you and I, it was really the first thing that I saw when Mark sent these over, and I asked him about it, and I thought it was interesting that you you noticed it right away too. So if nobody else has any issues with it, I guess it's just how we'll move forward.
Mark, can I ask?
DA Sunday and then Professor Rago. DA Sunday.
Thank you. Real quick, Judge Bernstein actually covered some of the concerns that I had with the term shall. If you look at the sentencing matrix, every quadrant is a shall. It just doesn't say
Right.
shall, if that makes sense. And as attorneys, we are trained, shall is the red flag. You throw that flag and everybody stops. And I excuse my ignorance. Are there any other places within the sentencing guidelines where the term shall is used? Mark?
Yeah, I believe there are, and I'd have to look at this. You know, every time we go through an amendment, we try to look for, inconsistencies or errors. And I know at one point we tried to be very consistent about the use of terms, and I think this was the explanation for why we would include shall, because we didn't want, especially the appellate courts, to look at the language and say, oh, well, the commission's giving you latitude to do, you can use that as a prior record score, you don't have to. And the commission's view was, no, we have to state what the rules are, but then courts have to be advisory. So I think I think Judge Bernstein's absolutely right. This is education, and we'll talk a lot about some of our education efforts, but we should build this into it. And maybe there's an opportunity with this amendment to make that very clear. The other opportunity is, although on the screen you'll see the beautiful colored part of the matrix, there's a lot of text below that, sort of explanatory information about the new categories, the confinement versus non-confinement. And one of the things we may be able to do is in there include some language as well about the advisory nature of the guidelines. At least, what we find is sometimes if we have it in writing, we can at least point to it and say, well, there's your, there's the explanation of this. And that's part of why we put the advisory nature of the guidelines in the policy section, so that we could point to that and say, yes, shall within this context. Professor Rago?
Thanks, Mark. Just quick. So if someone exceeds that sentence, let's assume a judge makes the mistake or just doesn't want to accept that, would that be construed as an illegal sentence?
Not illegal, but it would be a departure from the guidelines or an aggravated sentence. So for instance, let's say the aggregate sentence is we're recommending an aggregate of 5 years, and the court imposes a 10-year probation with non-restrictive conditions. It's a legal sentence as long as it otherwise is legal. It's just that it would be outside of the guidelines. And one of the things the commission could decide is, what is that? Is that just an aggravated sentence, or is that a departure outside of the guidelines? And there's a little bit of a different appellate review standard based on which category that is. But if it's outside of the guidelines, one of the things, let me give you an example. Right now, if at level 3 of the guidelines, someone is drug dependent, and the person just places the person into treatment without a clinical recommendation, it may be exactly the right thing to do, but it's considered a procedural departure because the guidelines say you shall have this assessment done before you place a person into a program, because judges aren't clinicians. And so the judge should have that information to make a decision about that. And so we say, yeah, you're not playing by the rules, and we've been pretty clear about the rules, but we'll just call it a procedural department. It's not an illegal sentence.
So in this context, shall is a term of art. It's not
Yeah.
what shall is. Okay.
Yep.
Thank you.
Judge Bernstein, may I just respond to DA Sunday briefly? This
Yes.
is Myers, thanks, with the commission. And just to note, the guideline text does use shall in a number of places historically, and often coupled with shall consider. The court shall consider the guidelines in a broader context. And just to also pick up on Representative Stevens and Judge Bernstein, through our education and outreach, that's the context within which we discuss the guidelines, just from a broader perspective. And it's one of these 3 guiding principles that we've come to really start most of our sessions off with that the guidelines are advisory in nature, that they're recommendations to the court. However, the court shall consider them as they're deciding their sentences. So thank you.
Thanks, Ryan.
Mark, it's Ed Marsico.
Yes, Judge.
Just to follow up, I sort of had the same reaction that everybody else did. I actually, and it might be the way the slide was laid out, I thought that was, when I saw that, I was wondering if that was part of JRI 2, the actual legislation that forbid that until you started explaining it. And I guess as a practical matter, most of these offenses are ungraded misdemeanors, M3s, M2s anyway. So you're not going to be able to go, way above the P1 or P2, as it's outlined. But I do think there needs to be a little finessing with that shall, because I thought it was that maybe that was the statutory language of JRI 2.
Sure, thanks, Judge. And that's a good point. And I think your point's also well taken in terms of for those individual sentence recommendations, P1, P2, we're not saying a whole lot in some of those cases because it would be the statutory max. Where it matters, though, is aggregation. You get 10 counts, and it could be a 20-year max. And so saying 5 years instead of 20 as sort of a starting point is, I think, important. So, well, look, staff will look at all this. I get that. And I know there's a tone thing, but it's more than tone. And so if, we'll continue to look at this and we might want to ask for comment during the public hearings about just how to frame that to make sure that we're being very clear that this is what the recommendation is. This is the starting point, but that, these are advisory guidelines. So really helpful information. So thanks. Judge, if there isn't anything else, I'll move on.
I'm not saying anything else. You shall move on.
Okay, thank you. So we have 3 other proposals before you, and again, we've spent quite a bit of time on all of these, so I'm going to move pretty quickly, but I do want to make sure I respond to any questions. So the first proposal, and this is really modest, is the resentencing guidelines. As you may recall, the commission adopted these last year. They went through the General Assembly's review, and they took effect January 1st of this year. So it's a pretty fast Amendment 1 coming up, but it does really 2 things. Number one is in Act 115, there was a repeal of county and state intermediate punishment. And when we developed the resentencing guidelines, we were actually required to have resentencing guidelines for those 2 sentencing alternatives, because these were all cases where the court would resentence following a revocation. Well, now all of that sort of combined or reduced down to probation. It's either probation without restrictive conditions or probation with restrictive conditions, but that's the only place where there would be revocations that lead to resentencing. So the first thing staff did was went through and removed references to county IP and replaced those references to probation with restrictive conditions and removed references to state IP. The second thing we did was when we were meeting with practitioners and rolling out the resentencing guidelines and everything else, we've had a lot of really good discussions, and particularly good discussions in Philadelphia with the Philadelphia defenders and with the district attorney's office about concerns about the language of the guidelines not being either precise enough or not clearly referencing statute that provides other kind of provisions. And the biggest thing, and we've talked about this in commission meetings, is that within the statute itself, when there's a resentencing in these cases now for probation, the court must take into consideration time served on the original sentence. And so we did not have that in the text of the guidelines, but I think it was a reasonable suggestion that we modify it to make explicit, to be very clear when the court's resentencing, the court's also considering the time the person's already served. And the situation that was raised, and I think this was also really useful information, was split sentences. there were a lot of cases that were discussed where someone received maybe a state prison sentence and a consecutive probation sentence. And they served the state prison sentence, they were paroled, and they successfully completed parole. And then while on the subsequent probation, they failed. And the concern was, oh my gosh, there's this huge sentence recommendation that's going to apply now as if this person's, for the first time before the court. And I think the clear takeaway that we wanted to communicate was, yeah, that recommendation may be there, but also all the credit time that has been served has to be considered as well. So we hope this clarification helps. And we think that addresses both the needs with Act 115 as well as a clarification of the policy itself. So unless there's any questions.
No questions noted.
Great, thank you. Moving on to the state parole guidelines. And this is, we've talked about this a lot. We had several, of course, staff has met regularly with the parole board, but then as you'll recall back in September, we had a joint meeting of the commission and the parole board to review initial guidelines. And then we've taken steps since those to address issues that were raised by the board and issues raised by the commission. And I think we're pleased with where we are right now. And we think it's time to approve these and move them to public hearings. Let me just give you two pieces of background information that I think are really important when we talk about parole guidelines. Maybe three things. So the first thing is that, in Pennsylvania statutorily, there is no right to parole. So the framework we're working within is that there's no right to parole, but there's always consideration of parole. So we need to make sure that that frames the issue. There are other states where the presumption is you are paroled at your minimum or whenever eligible, but that's not in our statute. And so we have to work with the statute we have. The second thing is that, there's no right to parole, but the legislation that we received said that we must take into account, we must build into whatever guidelines we come up with, a validated risk assessment instrument. And so there's a definition in statute of what we have to consider for parole guidelines. And one of the things we have to consider is a validated risk assessment instrument. So you're going to see that figures prominently into these guidelines. And then I think the third thing to keep in mind is that the parole board is an independent body. We are providing guidelines that we are providing to the board to consider. They're advisory guidelines, just like we provide guidelines to the court to consider its sentencing. These are guidelines for the board to consider when considering parole release. And the board can exercise its discretion. There is a reporting requirement. There are other kind of provisions in place, but the board can do other things internally. They certainly have access to much more information than we're looking at with these guidelines. But this is sort of a public process to have guidelines in place for consideration by the board, but they're advisory guidelines. And so moving to the slides, there's two categories to start with when we're thinking about guidelines. One is guidelines for violent offenders, and the second is guidelines for non-violent offenders. And there's a lot of ways of sort of slicing this, but for the violent offenders, there are not only provisions in statute that require certain types of offenders to have certain types of review by the board, but the board internally also has a protocol regarding voting requirements. Which decisions have to be made by a majority of the board, by 5 members in favor, which require a majority of a panel of board members, which require or can include hearing examiners. So there's a whole mix of things in how the board does its business or what the legislature has required of the board that we have to take into account as well. And that's one of the reasons we have these two categories. But we're looking at exactly the same factors in both of these categories. We just come up with a different recommendation if someone's in the violent category versus non-violent. And it's a modest change. There's a border cell that we swap from recommending refusal to recommending grant. But otherwise, the system, the procedure is consistent across the board. So I think if you look at the colored matrix that you'll see there, there are two scales that the commission considers. So as I said, the statute requires consideration of a risk assessment. And so one of the things we did was look at what assessments are used by the Department of Corrections and what assessments are used by the Board of Probation and Parole. And at this point in time, the most reliable, the best assessment that's being used for general recidivism, for general risk, is the LSIR, Level of Service Industry Revised. And so we have identified that, we've done analysis with that, and that is the risk assessment instrument, the findings from the DOC that would be used as part of this decision model. And we have three categories: high, medium, and low risk. The second category that we have, and this is, I think, this has been a great cooperative effort with the board and a real engagement that I think has been productive, is to come up with a new category that's fairly objective, based on what we call preparedness. And there's a lot of factors that go into preparedness, but there are things that are in the record or based on the behavior of the person in the institution. And those are what we call the pre-interview factors, factors that contribute to a person being prepared, completing programs, other things like that. Some of these are statutory, some of these are things that have been used in the past, some of these are things that are statistically significant. And then the second category, and this is something that we've tried to objectify when it was more subjective in the past, is what happens during the interview. Because in each of these cases, there's going to be an interview with a board member and or hearing examiner and with the individual that's applying for parole. And the question is, what happens there? And how do you make sure you have consistency across the board members and hearing examiners, that you're being fair and objective about this? And so that's what we spent a lot of time on, trying to understand what were the factors the board was using and what were the factors that were actually positive in terms of good outcomes. And so those are built into this second scale that we created called the preparedness category or scale. And so the combination of the two, look, there's only two decisions that can be made following an interview, either to recommend or to refuse parole. And so, and then all of the information, let's say a board member or two are involved in interviewing a case, an individual, they're going to have a recommendation, but maybe there's other board members that have to sign off on it to actually get a release. Well, we want to make sure that all of the information is consistent as you're moving it down through the system, that it's not all subjective, that there's an objective base. And we think this does that. So if you look at, what we have listed here, I think we have, in effect, the framework that takes into account risk and preparedness and comes up with an initial recommendation of either to refuse or to grant parole. And Ryan, the next slide. Thank you. Now, this is a little hard to see, but you can, it was certainly in the handout packets you have, and we dealt with this in previous meetings. But, one of the things, I think one of the second things that we have to think about is, are there any things statutorily that run counter to our recommendations? And so, for instance, think about a case where we're recommending release, but the parole board cannot release because the statute prohibits it. So for instance, if a sex offender does not participate in treatment, the board is prohibited from statute from paroling the person. So we wanted to capture those kind of situations where the recommendation may be one way, but there are other factors that are really important and overriding factors that have to be considered. And so that's why we came up with this category called override factors. So think in case of the sex offender treatment requirement that I talked about, but think at the other extreme. Think about a person that, based on all of the information, is not recommended for parole. the person has not participated in programming, the person has had a lot of misconducts. There's a lot of things that aren't looking good. And if your starting point is there's no right to parole, the presumption would be, well, we're not going to parole. But the parole board has to balance a lot of factors. And part of this is it is not particularly good to have someone max out without any kind of reentry, structured reentry into the community. So there are going to be times when someone does not look like a good risk, would normally be applied parole, or denied parole, but maybe a year or two from maxing out and may have been confined for many, many years. And the board is in a very difficult position there and is trying to determine the right balance. And so that might be an override in the other direction, where although the recommendation might be do not parole, the board might actually want to move in that direction to at least provide some kind of structured reentry. Because the board's bottom line is public safety. And so we tried to come up with a system that we could document these things, and we think this hits the right balance. So I don't think there's anything new here from what we've presented at the last meeting and what we've generally discussed over the last couple of years. But unless there's any kind of questions, we'll be moving this forward to public hearings.
Judge Bernstein, any questions? I think we're all good. Okay, go ahead.
Great. And then the final issue is the state parole recommitment ranges. And we've worked on this for a number of years and basically have tabled it, but the General Assembly has created a statutory framework for technical violations. And so there's sort of minimal work that we've done on the technical side because the statutory provisions really structure that. So we'll be capturing that information, but we're not adding a lot of value. But where we do add value, I think, and where the board has been welcoming this this recommendation was when someone commits an offense while under supervision on parole, and providing some structure around the recommitment ranges, the back time recommendations for those individuals. The board has always considered the seriousness of the new offense committed in terms of determining a recommended back time, which the person would go back to serve and then be eligible at the completion of that for re-parole. And the commission has reviewed these before, but these are the recommendations. One of the, I think, benefits of this structure where we link the recommendations to the offense gravity score is that that when the person is charged and convicted of an offense, the offense gravity score for the most serious offense is known, and that is consistently then used by the board for this purpose. Again, these are advisory, these are ranges just like with sentencing guidelines, but this is the mechanism whereby the board has a standard in place, a starting point for recommitment ranges. So I don't think there's anything new here, but I'll open it up for any kind of comments or suggestions.
Any questions? All right, I think we're good.
Okay, and the closing slide is where we started with JRI 2, but this is Act 114. This was the act that provides funding and a new mechanism, a new advisory committee at PCCD to help to support county adult probation and parole. And this new advisory committee and PCCD will have the responsibility of deciding how to distribute funding. And there's, in effect, 3 funding sources that they'll be looking at over time. The first is the existing grant in aid funding, the funding that is provided to county probation and parole to support professional services. The second is what was called the county intermediate punishment funding. I guess it will continue to be called that. And that is, the county has a county IP plan, is eligible for some funding to support county restrictive intermediate punishment programs, restrictive conditions of probation now. So that's the second pot of money. And then a third pot of money is being established, and it's going to be money generated through savings from JRI 2 that will be reinvested in county probation and parole. And so as part of this enterprise, the Commission on Sentencing has been given the responsibility of doing a certification of compliance for counties' compliance for use or for consideration in getting that county IP funding. And you'll see that there's a number of things we're supposed to consider in a certification formula, but it includes first that the court is completely reporting sentences to the Commission, all sentences. And so we have a regular process you'll hear about later, and this is just to try to promote compliance with full reporting to the Commission of Sentencing data. The second is that the county has a county IP plan and is sort of operating in accordance with the county IP plan. And then the third is that the court is abiding by the statute in terms of eligibility and use of these restrictive programs. And then the fourth is consideration or compliance with the sentencing guidelines for restrictive conditions. So those are the metrics, the factors that staff will be collecting information and then using in terms of certifying compliance. And this certification has two values. As I said, the first value is if a county is not certified, they cannot receive county IP funding. So that's a big deal. The second thing is this information is provided to PCCD's advisory committee, and that committee can use the information we provide in any way they want to in trying to determine appropriate funding for counties, how they distribute funding. So this is an important role that we have. I think it'll improve the quality of data and operations, evidence-based practices. So it's all good. We're right in sort of towards the end or the middle of the cycle of funding right now, and it seems inappropriate to try to do anything this year for certification except to collect this information, report it back to president judges so that they know sort of the baseline of things in their county, because next year we would have a certification process in place that's going to count. And I think between now and then, hopefully at the September meeting, staff could bring back to the Commission maybe a formula or a framework for what a certification would look like. Make sure we have the Commission's support for that as the mechanism by which we do certification. And then we'd share that with president judges. There's one other factor that I didn't mention that's really important too, and this is that counties are required to provide to our Commission and PCCD information on restitution collections. And so we'll be working with PCCD and with counties on making sure that we have that information, because that's also part of the certification process. So with that, I'll turn it back to the judge. I think we're done and we have about 10 minutes before the formal meeting.
All right. Any questions on that last component? With that, then my understanding is we're asking everybody to just stay signed in for the meeting at 11 a.m. I'm assuming it's about 10:52. Do you want to start at like 11:02 so we have a solid 10-minute break for those of us who are drinking coffee or need to let our dogs outside?
Sure. Sounds good.
Or both. All right, so we'll convene just after 11 a.m. Everybody, please stay on and make sure to hit your mute if it's not already hit. And then I believe Representative Stevens will be opening up the meeting at 11 or just after. Thank you so much.
Thank you.